Good. Mic's on. Go ahead.
All right, fantastic. Thank you for the patience for everyone on the phone and here with us in person. I'm going to call us back into regular session at 11:06. And based on our conversation in executive session, I would seek a motion that the board both approve ADE's recommendation for the selected vendors for the new ELA and mathematics assessments for grades 3 to 8 and high school, pending review by the Joint Legislative Budget Committee pursuant to the Arizona Revised Statutes 15-741.03, and pursuant to the board's 5-year assessment plan, direct the department to seek peer review and any necessary contracts to provide assessment choice in high school with the assessments that are currently on the menu of assessments and that responded to the statewide assessment request for proposals. I seek a motion and a second to that effect.
So move.
Member Baker, thank you. Do I have a second?
Second.
Member Mack, thank you. Any questions or conversation? Hearing none, this will give you an opportunity to unmute yourself, and I would seek those approval of this motion, those approving of this motion to indicate by saying yes or aye.
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 Aye. Yes.
Thank you. Anyone opposed? Fantastic. Thank you very much. I believe we have unanimous approval of the motion. So we will move on to item 5C, and this is for information only, an update on legislative affairs. Director Williams.
President Arducci, Vice President Core, Superintendent Hoffman, members of the board. Board staff brings this item to the board after every legislative session to walk the board through legislation that has passed and signed into law and legislation that has failed to do so. With that, Deputy Director Bellin will lead you through the attachment.
Vice President Core, Superintendent Hoffman, and members, so the first page here that was included in your board materials encapsulates the entirety of the legislation that passed that our board needs to take action on. ESAs was a whole agenda item, so we could skip past that one. And so that really leaves us with House Bill 2625, which declares September 25th as Sandra Day O'Connor Civic Celebration Day, with some exceptions if it falls on a weekend. And the board is required to adopt a list of resources and establish a process for schools to add to that list of resources. We've already had a really good conversation with the folks at the Department of Education and their standards team, who are really passionate about civics themselves. And we feel like we have some good first steps that will be in place that we'll be able to make some recommendations to you at the next board meeting in August to adopt those resources and the process. I think we'll be pretty excited about that. And that's the extent of the signed legislation that requires board action, and that's largely because the legislative session was shortened significantly as the result of the pandemic. I think we had something like a record number of bills introduced and a record low of bills passed for the last several years anyways. The record number of bills introduced was probably ever. But outside of the legislation that was passed that requires board action, of course, there are a bunch of legislation that failed as a result. We think on board staff that we would probably, so these are just 3 of them, and I'll remind you, we started putting a draft of this first list together of possible bills that would pass in early March, and there were 18 bills on it, and so 2 ended up on it, with the addition of the school closure bill, which was 3. But of those other legislation that failed, there are some things that the board could still do, specifically around Holocaust instruction, House Bill 2682. The board does not need statutory authority to do this, and so we think that's something that the board should probably pursue, and we might bring you something in August to essentially implement that more or less the way it was written in statute. So that's really all that I need to go over here, and I'm happy to answer any questions if you'd like, and of course we're on the lookout for a possible special session that May or may not happen in the next couple months, but if it does, of course, we'll keep you updated as best we can.
Members, any questions for Ketcher? Okay, hearing none. A session unlike any other, huh, Ketcher?
Indeed.
So I will move us on to item 6, another call to the public. This is the time for the public to comment on items on the consent agenda portion of the certification enforcement action. It is my understanding that no written comments have been submitted. Is that correct, Director Williams?
Vice President Core, that's correct. For this agenda item, no comments were submitted.
Fantastic. Then I will move us on to item 7, which is in fact the consent agenda for certification enforcement actions. Board members have received this well ahead of time, and I am not aware of anyone who wants to remove one of these items from consent agenda. So with that knowledge, if that is in fact correct, I would seek a motion. Do I have a motion to approve the consent agenda items 7A1, 7A2, 7A3, and 7B?
So moved.
Vice President Core, one of the board members on the phone, you have the live stream going, so in the boardroom we're receiving an echo of our meeting in here, so if you could turn the live stream off potentially and then a vote. So Dr. Core, right now we have a motion to approve the consent agenda items 7A1, 7A2, 7A3, and 7B. That was motioned by Member Mack.
Correct.
We're waiting on a second.
Second.
Member Baker with the second. Any conversation or questions? Hearing none, now you can unmute, and I would seek all those in favor of approving the consent agenda for certification enforcement actions to indicate by saying aye.
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 Any opposed indicate by saying nay. Thank you so much. Hearing none, we have unanimous approval of the consent agenda certification enforcement items. Item 8, once again, a call to the public. Director Williams?
Vice President Core, members of the board, I do believe we're starting to have Kim Anderson and Kathleen Harrington join the line, which is our legal team for educator discipline cases. If Kim and Kathleen can also mute their phones. Thank you. For item 8, the request to speak, we do have some individuals in here in person, but for the record, I do want to note that we had a public comment from Mr. Horton attached to item 8, and then 70 public comments for Krzyzanowski's testimonials attached as well. And by the way, for the board members who are on the phone and in the room, some of these individuals are waiting in their cars and watching the live stream. There is a delay to the live stream. I will call names out 2 at a time, just like we always do. Individuals providing public comment will have 3 minutes, and the board members can't really discuss the comments. So,
Right.
first up, we have Richard Krzyzanowski, followed by John Checkett. Okay, first up, we have John Checkett, followed by Richard Krzyzanowski.
Welcome, John.
All right, thank you, Mr. President, members of the board. My name is John Checkett. I'm the managing partner of the Checkett Law Firm. I'm appearing here with Richard Krzyzanowski. He's affectionately known as Mr. K by his students at Chaparral High School. His case has already gone through PPAC, I understand, on February 11th, and he was not represented by an attorney at that time. He contacted me after the PPAC hearing, after the record had been made in this matter, and I wanted to be here for him today. In full disclosure, I'm taking no compensation, would not accept any compensation as an attorney for Mr. K, because that is what people do in their high school community. That's what Mr. K has already done for my family. The world should be as tolerant of others as Mr. K is. Mr. K, I'm not only speaking as an attorney, but as a parent. Mr. K has taught 2 of the 4 of my children. The saying in Mr. K's classroom by one of my kids is, Mr. K gets it done. For my other son, he was the best math teacher he's ever had in his life. Both of my kids are high academic, high performing kids. All four of them are. So I can speak to not just being a lawyer. Outside of the classroom, Mr. K has volunteered for everything. He's a girls swim coach, assistant basketball coach, head girls basketball coach. He operated the scoreboard at all the numerous sports, just not his own. And he's been the life of that school for the past 6 years since he's been there. He's a very positive person, and it's always about the kids for him. And in being here today, I understand the board is limiting my statement to 3 minutes. I understand the formal record is closed. I can tell you in the 3-minute limited time that I can't go over everything that Mr. K has done for everyone, all of those kids. They actually had a Red for Richie Day at the high school. And today, however, I'm hoping that you will use your discretion in not adopting the PPAC's recommendations. And here's why. Basically, as an aside, you've got a person who is all about the kids. He's coached the girls' swim team for 6 straight years. Luckily, they had 6 straight state championships. But that's not what it's about, is how many kids he has affected and how many times you come into contact with a girl swimmer. And there are no complaints about Mr. K. He is the best. He's talked people off the ledge, given our drug culture in today's society, and it's real tough being a teenager. He was an All-American swimmer at GCU. He got his Master's of Education Administration at GCU. In addition, when the girls' basketball coach left, he stepped in. He was coaching them for a year and a half. And he's just an absolutely fabulous individual. And so when I look at what the PPAC has recommended, again, I wasn't there and didn't have the opportunity to weigh in, is you look under R7-2-1307, and I know those are offenses for which you can revoke permanently, forever, and ever. But there's 44 criminal offenses there. The recommendation that PPAC jumped to is revoking his certificate for 5 years. What I would ask of this board is to use your discretion, and people like him don't come along very often. And whatever you, Mr. President, whatever you think, and board members, or don't think who he is or what he submitted or what he did not submit, you have the ability and the power under the statutes to put him on a period of probation, to put him on a shorter period of suspension, to where you can require and say, Mr. K, go ahead and retake these tests that we dispute that you have as your credentials. Go ahead and do these things, because people like him do not come along very often. And you have not heard one complaint or any disciplinary action from him when he's involved with hundreds and hundreds of girls and boys throughout. And there's no complaints about his teaching. And again, that's why I would be urging, and thank you for your time and consideration, to, with due deference to all the record that's already been made, but give Mr. K a chance. Put him on probation, or if you believe suspension is appropriate, but revocation is not. Thank you very much.
Thank you.
Next up, we have Richard Krasinowski, followed by Jess Lorona for Oates.
Please, Richard. Yeah.
Members of the board and everyone here through video call. My name is Richard Krasinowski. Teachers are people who make an impact on the future generations in the classroom. Forever teachers are people who make impacts on the future generations in the classroom and the walls beyond the classroom. Everlasting teachers are the ones that make an impact on future generations in the classroom, beyond the walls of the classroom, and an inspiration for them to continue coming back to you for advice, care, and guidance that will shape their lives every single day. For the past 6 years, my students would identify me as one of those everlasting teachers. My wall next to my desk, and actually taped on my desk in my classroom, is filled with handwritten letters, graduation cards, and ways to remember the amazing experiences that they have had in my classroom. Not only as their mathematics teacher, but someone they can constantly go to for any guidance at any point in time. My day would start at 5:45 a.m., where I have students looking for math tutoring in my room by 6:15 a.m., an hour and a half before school started. Then the day would proceed to teaching mathematics with 6 classes compared to the normal 5 because we didn't have enough math teachers with an average of 38 students. This year, in particular, 42 in my mathematics classes ranging from Algebra 1, Geometry, Algebra 2, Honors, Algebra 2, AP Statistics, and tutoring any other subject that would come into my classroom needing assistance at any point of the day. My day would end at 9 p.m. only because that was after being a teacher instructional leader, mentoring other new teachers on teaching strategies and classroom management. I was on the mathematics curriculum team within the district, and then finally coaching 3 varsity sports of girls and boys swimming and diving, girls basketball and sand volleyball. That's just a small glimpse of my day, but what I take pride in the most is the everlasting relationships with every student that I have had over the years and after their time at Chaparral High School. One of the greatest feelings every day is walking into school with a huge smile on my face and leaving school knowing that I impacted every student that stepped foot in my classroom with an even bigger smile. My students and their presence in my classroom is what drives me to be the best mathematics teacher every day. Nothing ever stopped that because my students were the number one priority, growing in their comfort level in mathematics and feeling confident in their mathematic capabilities as they move on to higher levels of mathematics. Many say that teachers make many sacrifices. I don't think it's a sacrifice. I believe it is my job and my love to do whatever it takes to make all students achieve their greatest in mathematics, regardless if they're my students or not. Their time is the most valuable, and I will do anything in my power to make it that everlasting feel that will be there with them for a lifetime. There's a famous quote by a very prominent educator figure, Harry Wong. He states, "It is the teacher, what the teacher knows and can do, that is the most significant factor in student achievement." My role has been exactly geared to student achievement in my classroom as a mathematics teacher, and even more than that, of making them prepared for life lessons. Over these months, being out of the classroom has impacted my students and myself of not having the teacher that they have relied on over the years. Yes, other events have occurred and we are still currently battling them, but not being in the role that my students have been so accustomed to seeing me has hurt them as well with me from guiding them through their academic endeavors and the current events we are battling daily. Teaching isn't for everyone, but it is a very acquired taste for those who test those waters. And those waters are ones that test the real teachers who are ready for anything that steps in their way, and that is what I have been doing for the past 6 years. If you ask any student, colleague, principal, parent, or community member that knows me, appreciates everything that I have done at Chaparral High School, and can say that the everlasting impact in the classroom and beyond the walls of the classroom is in fact real and has been cherished. I hope you consider my role as a teacher and the impacts I have made on every student that has stepped foot in my classroom. Thank you to the members of the board for letting me speak here today.
Thank you.
Just so the board members are aware and the public is aware, Jess Larona is representing 3 different educators today.
Okay.
So Jess Larona is next, followed by Jess Larona, followed by Jess Larona.
Okay.
And for Jess, for your information, it goes Oates, Bellin, and then Smith. So first up, we have Jess Larona for Advocate for Teacher Oates.
Sorry, for who?
Oates.
Jacqueline Oates.
Jacqueline Oates.
Thank you.
95.
And my only purpose, addressing everyone that's present today and on the phone, my only purpose in requesting to speak today, this was a negotiated settlement agreement. Based upon the conduct, I wanted to make myself available to answer any questions, if anyone did have any questions, but with respect to any direct statements, I do not have any direct statements at all to make. If the board is going to approve the negotiated settlement agreement, I really basically have nothing further to state.
Okay, do you want to move on to Bellin?
Yes.
Okay, so the next comment is for Bellin, item 9D1.
The Leslie Bellin matter is more concerning to me from the standpoint that a teacher could in fact enter into an agreement with the board that it essentially waives their rights of due process and rights to a hearing. At the time that she entered into the settlement agreement addressed 2 DUIs, one dated July 9, 2006, and another dated September 15, 2014. The settlement agreement was entered into on June 26, 2017. The board adopted the DUI Matrix on September 25, 2017. So that was just, we're talking 3 months, 2 to 3 months after she enters into this agreement. The board adopts this DUI Matrix. and updated it on September 25th, 2018. The DUI matrix provides that for 2 to 3 DUIs, if you reach a settlement agreement, it's 1 to 2 years. If it's a contested matter before PPAC, it's 2 to 3 years. If it's more than 3 DUIs, it's 2 years with conditions if it's uncontested by a settlement agreement, or 3 years with conditions in front of PPAC. So she gets this third DUI, which if the matrix were in play, she could be looking at a potential suspension of 2 to 3 years. But because she signed the settlement agreement 3 months before the matrix was adopted by the board, she's getting hammered for 5 years. And once again, we don't believe that's fair from a due process standpoint, but I don't understand how any teacher can waive their due process rights or waive their rights to contest any matter. In essence, by signing this agreement and by the board's conduct in adopting this matrix, she's just saying, okay, even if we later on change the procedures and policies, you don't get the benefit of that because you basically waived it. And so we're asking for consideration with respect to what's happened with the board and how they address her situation. We provided documentation. She's a great teacher. It's unfortunate that situation existed. She was afraid when she got that third DUI. She was afraid to notify anyone. She wanted to continue teaching. She blew it. But really, in addition to that, we have nothing else to say.
Next is Jess Arona for 9E3, which is Smith. And Mr. Arona will also have time during the agenda item to address the board because it is a matter of rehearing.
Fantastic. Thank you. Thank you for that clarification.
Smith is 9E3.
Okay. With respect to Tasha Smith, our concern is once again looking at the matrix. We feel the imposition of the 18 months as opposed to 12 was excessive. If you look at the matrix and the conduct that's addressed in there, disorderly conduct isn't even one of the considerations that's listed at all. In fact, when you look at the matrix, it relates to alcohol and work, but not alcohol outside of work. And it was a disorderly conduct situation that occurred at a Tempe bar that there were allegations that she had been drinking. We believe, based upon the testimony that was presented, it wasn't very strong evidence, but PPAC basically made the decision that based upon that disorderly conduct and her conviction for the DUI, the extreme DUI, that they were going to impose 18 months as opposed to the 12, and we don't believe that the findings facts necessarily supported the multiple offense requirement that's set forth by the matrix, and we're asking the board to impose a suspension of 12 as opposed to 18 months. And when I came here today, I didn't believe I could make any argument under 3 minutes.
And Mr.
And yet you did.
You'll have time during 9E3 to address the board as well.
Okay. Thank you.
Thank you.
Okay, next up we have Denise Blummel for item 9A1. And then Flynn Carey will be next.
Hello.
Good morning, Mr. Vice President, members of the board, Superintendent Hoffman. My name is Denise Blommel, and I represent Gerald Alfieri. The board tabled this negotiated settlement agreement back on April 20, and my understanding is 2 board members had some concerns. I don't know what those concerns are, but if one of them was an issue as to whether there were an irregularity in a merit test, the answer is Mr. Alfieri never proctored any merit test while he was at the Department of Corrections. So I'm here to answer the questions of the 2 board members that wanted to table this and set your mind at ease. This is a negotiated settlement agreement for a letter of censure. Mr. Alfieri is a longtime teacher. Again, there was no merit test involved. So here to answer questions.
Thank you, Denise. We're really in an awkward situation with all this right now. So if there's any questions and if any members pull a negotiated settlement agreement, then we can have Denise.
Not during the call to the
address.
public, but during the agenda item itself.
Correct. That would be appropriate, given the circumstances.
And may I then address the board if they have questions?
Yes, I think we
That
can
would
do
be
that.
great, but again, I wanted to reassure you, there's no merit test involved here.
Okay.
Okay.
And again, just to reiterate, during the call to the public, we don't, there's no back and forth, so you've kind of had your say. We will call that agenda item in the very near future once we're done with call to the agenda. If there's a direct question from any board member that they would like you to address, I would certainly give you that opportunity.
Thank you so much.
Okay, thank you.
And next we have Flynn Carey for item 9A4. And I believe Mr. Carey, you can say the same thing that.
Thank you.
Uh-huh.
Mr. President, members of the board, I am here on the Nichols matter. It's a negotiated settlement agreement. It has some, I think, curative measures in it as well. I am here to answer questions and available. Under the new system, I've been putting my name in as a request to speak,
Right.
simply so you know I'm available.
Thank you so much. I appreciate that. And again, if any board members have any questions, I would certainly allow those to be posed and the appropriate counsel to respond.
Okay, next up we have Roger Frazier for item 9E2. And that's Jose Jimenez. Just so the board members know, Mr. Frazier will also be able to address the board during that specific agenda item because it is a rehearing.
Good morning, Mr. President, members of the board. I'm Roger Frazier here for Mr. Jimenez. We had 4 items on, these are basically legal points for this motion for rehearing. And one of those, the first one is the counselor statements that were testified to by a third person. And the issue in there was surprise. That was the ground that we seek a rehearing on because a third person, I think it was the school HR person, Ms. Zuniga, basically was saying that these counselors told Mr. Jimenez at a particular time, a month or two before the incidents that were at issue here, that this student had a crush on him. And in his testimony, he said that didn't happen. Nowhere prior to the hearing was that one of the allegations. So we did not subpoena those counselors. And the problem is, had that allegation been put out there, of course we would have subpoenaed them because he disagreed with that. And then in the deliberations by the PPAC, that was basically a pretty major issue. So the state says that although the PPAC the PPAC said we have enough to go on, that was one of the points that they went on. And if we had a chance to put that forward, that could change the outcome on other things as well, because then the whole credibility picture shifts. The second item is the legal question of when a teacher needs to contact authorities. And I think in kind of the way this came out, this was not a particular finding. It was not one of the written findings, but it was one of the ones that were discussed, and you could see in the deliberations it made a difference. And the testimony shows that the student never spoke of abuse, but Mr. Jimenez thought she might tell him something, but just didn't have enough information to go on. And when you're in that nebulous area there, if you read both the rule, the governing rule of the district, plus the statute that goes with it, or that it's based on, he did not rise to a level where he had to give this notice. That's a legal question that was considered there. Next issue is the affidavit. I mean, the text messages. If you recall, this was a matter about a number of text messages between student and the instructor. And we tried to get those from the Nogales Police Department, who did not state that they did not have them. And by the time we figured out what was going on there, it was too late to bring them up and do a motion to quash. They did not do a motion to quash. And I think the state's position is that, well, it doesn't make any difference. There were texts, and that's all you need. But I remember there was testimony at the hearing by some authority about how some text messages can't be saved, like Snapchat. That wasn't Snapchat, it was WhatsApp, I think, but that these disappear. But in this case, the police officer said he saw those, and every other text message from those phones was printed out and given to me and brought here, but the message at issue. So they were withholding that. They didn't say they were withholding them. And as a matter of fact, they don't have a right to withhold them unless they can show that it's detrimental to a state interest. And in this case, Mr. Jimenez would have seen those messages to begin with. So I don't know what their defense would be, but we should have an opportunity to present those. And so with all of those points, if we have a rehearing and those messages are innocuous and the counselors don't support the hearsay testimony that was previously relied on, certainly, even if he's not exonerated totally, it might make a big difference in the outcome. It might exonerate him totally.
Okay.
A lot of this is admitted, what he did, but certainly not all of the allegations were admitted.
Okay.
So, okay.
Thank you.
And I will wait in case there are questions.
Fantastic. Yes, absolutely.
And finally, board members, our last request to speak is from Clarence Horton. I did converse with Mr. Horton. He does not need to speak at this time, but he's available if the board members have any questions in regard to his case. As well, he has submitted a written public comment, which all of you have read over the weekend.
Fantastic.
So with that, that concludes the request to speak.
Okay, very good. Thank you so much. Moving on to 9, the general session certification enforcement actions. So at this point, we have 6 negotiated settlement agreements. Alfieri, Chinchilla, Duran, Nichols, Oates, and Thompson. 6 negotiated settlements. Would any of our board members like to remove one of those and discuss it separately? If not, I would entertain a motion that would approve items 9A1 through 9A6.
I'd like to remove item 2.
Okay, at this point then, I would seek a different motion. I would seek a motion to approve item 9A1 and 9A3 through 6.
So moved.
Okay, that was close. I'm going to give it to Member Mack by a nose over Member Baker. We'll circle back and do 9A2, but we have a motion. We have a second to approve items 9A1 and 9A3 through 6 negotiated settlement agreements. Time to unmute, folks. All in favor of that motion, please indicate by saying aye.
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 Any opposed, please indicate by saying nay. Thank you. Now we'll address separately item 9A2, the negotiated settlement for Christopher Chinchilla. Member Baker?
Could I have the staff review that?
Sure.
That case.
Sure. So, Dr. Kaur, members of the board, I believe this is Kathleen's case, and she is on the phone. Let me just double check that. Just want to make sure I have our...
Alicia, it's Kathleen.
Okay, thank
It
you.
is not my case.
Oh, it's Kim's case?
I don't believe either one of us had this case. I think it was handled by board staff.
Who drafted the negotiated settlement, ladies?
I did not, Kathleen.
Kim, it's Kim's case. Okay, so Member Baker, members of the board, Christopher Chinchilla came to the board originally back in, if you look at attachment B for the negotiated settlement agreement. He came back to the board in 2018. The board, in attachment C, June 27th, 2018, determined to adopt the findings of fact and conclusions of law, but to suspend Mr. Chinchilla through November 3rd, 2020, beginning June 25th, 2018, and that all states and territories be so notified, with the condition that if any and all probationary terms have been set and the Class 6 undesignated felony is redesignated as a misdemeanor, the respondent is at that point allowed to reapply for certification and return to the PPAC. In Mr. Chinchilla's instance, he has met the conditions that the board put on at the board meeting on the 25th of June. The Class 6 undesignated felony has been redesignated as a misdemeanor, and therefore he reapplied for certification. Prior to scheduling a PPAC meeting, the board staff worked through the AG's office and Kim Anderson to offer a negotiated settlement that said we would grant his application for certification. Now, I will say that if the board today decides to grant Mr. Chinchilla's application and approve the negotiated settlement agreement, that does not, Mr. Chinchilla's information, the information the board members see at this board meeting, the information that was presented to the board at the June 2018 meeting, all of that information is still public record. All of that information is still within the state data systems. So any HR director who goes to hire Mr. Chinchilla would see that he has discipline on file, and they would be able to go through and determine at a local level whether or not they would want to hire Mr. Chinchilla for that position. With that, I can answer further questions if there are more questions.
Member Baker?
Yes, Vice President Kaur and members of the board, I just see a significant pattern of irresponsible behavior here, and I'm uncomfortable with just simply approving certification. It's not just, if I'm reading things correctly, it's not just the offense that brought this forward, but it's also driving without a license, without registration, without insurance. And I think we are responsible to holding the teaching profession to a high level. So that's why I asked for this to be pulled.
Thank you. Absolutely. Would anyone else have any thoughts or comments regarding 982, Christopher Chinchilla? Okay. Hearing none, I will still seek a motion to approve the negotiated settlement for Christopher Chinchilla. Do I have such a motion?
So moved. This is Member Wellborn.
Member Wellborn, do I have a second?
I'll second. This is Member Broussard.
Thank you, Member Broussard. I have any further discussion regarding this matter? Okay, I'll alert you to unmute, and I'll call for those in favor of approving the negotiated settlement for Christopher Chinchilla to indicate by saying aye.
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 Any opposed indicate by saying nay.
Nay.
Thank you. So if I'm keeping this straight, we will now move on to item 9, general session certification enforcement actions. And just a
9B.
9A.
9B as in boy.
Yeah, 9B. Okay, that's right. That's we don't have a name on A. Okay, so thank you. Confused myself. So item 9B, this regards the presentation, discussion, possible action on findings of fact, conclusion of law, and recommendation of the PPE, Professional Practices Advisory Committee to revoke all licenses and certificates held by Richard Krasowski. We've heard from Richard and his counsel earlier. Do I have a motion to adopt the findings of fact, conclusion of law, and recommendation of the PPAC to revoke any and all certificates held by Richard Krasowski for a period of 5 years, with all states and territories being so notified?
So moved.
Member Baker, do I have a second?
Second.
Member Mack, any discussion regarding this matter?
I have a question. This is Member Wellborn.
Please, Member Wellborn, go ahead.
I'm not understanding why it's such a severe discipline of revoking for 5 years. Do we have any? Is there anything in our matrix or what have you that would indicate why this is the right? This is an appropriate level of discipline versus other options. Can we review what the PPAC considered in terms of levels of discipline?
Dr. Kaur, Member Wellborn, the discipline matrix does not have an item that is aligned with the matter brought forth to the PPAC and to the board in regard to Richard Krasowski. Therefore, the PPAC members looked at the testimony provided by the respondent, the state witnesses, and the exhibits presented thus forth, and provided the recommendation of revocation. If you want, Member Wellborn, I would be more than happy to look back into the transcript and point out areas in which the board or the PPAC members discussed the recommendation.
Well, do we have any precedent in this case? I mean, I think what are other types of offenses that result in a 5-year suspension? They're pretty egregious offenses. Is that correct?
Dr. Kaur, Member Wellborn, revocations range from DUIs to sexual contact to inappropriate communications to drugs. I mean,
Right.
Revocations run the gamut within the educator discipline cases. So as your question of asking the historical context of the matter in which Mr. Krasowski's case came before PPAC, I myself personally have seen a few cases in which certifications were given to other individuals in the same manner with questions pertaining to the AEPA subtests, and those certificates had been withdrawn by the department or had gone through PPAC and had been revoked. Normally, we see cases at the board level in terms of fraudulent transcripts, not so much the assessments that are needed to gain certification in the state of Arizona.
Okay. In our packet, we have a similar case, I suppose, with Mr. Austin Nichols, who they created, that resulted in a negotiated settlement. Is it fair to make a comparison between this case and Mr. Krasinowski's?
Member Wellborn, I would not make a similar reference to the agenda item 9A4 and 9B.
Okay. Well, I guess I would say that I find it difficult to support a 5-year suspension on this grounds. I don't have enough information to present that it's egregious enough to compare to other ones. And it also seems to me that we could validate some of these accusations that appear to be more a he said, she said, and lost information and perhaps some confusing facts or what the facts of the records are. So I can't support an approval of this.
Hi, this is Member Broussard.
Yes, please go ahead, Member Broussard.
I just wanted to comment on this, and I was moved by the comments made by counsel on behalf of Mr. Pei, and what a seemingly great influence he's been on students, and Member Wellborn, I absolutely, I do think 5 years seems like a long time, but when I look at this and there's more than one instance where it appears he's going to great lengths to be not truthful about things, just unfortunately, whether that was a bad decision on his part or something lost, it appears that it was a bad decision and kind of reflects poor character, and we don't want to model that to our students, and we also we want to show our students and our community and state that we're serious about the standards we hold for educators in Arizona.
Thank you, Member Broussard. Any other thoughts or comments?
This is Member Wellborn. I'd like to add one more comment to what I said.
Yes, please, absolutely.
Thank you, Member Broussard. I appreciate what your point is. I mean, my issue here has more to do with the severity of the discipline. You know, we had another case where students were clearly impacted by the results of fraudulent behavior. We had a case of a teacher that was helping students to cheat on their material, on their tests and whatnot. So there's clearly harmful effects on the students. In this case, it did not appear that there was any harmful impact on students, perhaps irresponsible behavior on the part of the teacher. So it's just a matter of, what's the appropriate punishment. With the prior incident with the teacher that was helping students to cheat, the recommended discipline was censure, and in this case, it's a 5-year suspension. It just seems excessive. So thank you.
Thank you, Member Wellborn. Member Mack.
Vice President Corr, Superintendent Hoffman, members, I would just point us to the transcript, page 167, and it is quite clearly outlined when the PPAC state their findings of fact and conclusions of law prior to their vote of 5-0.
Thank you. Thank you, Member Mack. Any other thoughts or conversation regarding this issue? Director Williams, I'm fading fast. Do I have a motion and a second already, or am I asking for one?
Dr. Corey, you do. You have a motion to adopt the findings of fact conclusions of law and the recommendation of the PPAC to revoke any and all certificates held by Richard Krasinowski for a period of 5 years with all states and territories being so notified. That was made by Member Baker, seconded by Member Mack.
Fantastic. Then I will allow one more opportunity for questions or comments. While folks are unmuting. And then I will ask for all those in favor of supporting this motion to indicate by saying aye.
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 Any opposed indicating by saying nay.
Nay.
Thank you. That was Member Wellborn. Thank you. That is approved. We're going to move on to item 9C. This is a presentation, discussion, and possible action on the findings of fact, conclusions of law, and recommendation of the Professional Practices Advisory Committee to grant the application for certification for Clarence Horton III. Clarence has submitted written testimony, I believe. You can't see this, but he's nodding yes, indicating that he in fact did that. That's been shared with the entire board. So at this point, I would look to have a motion to adopt the findings of fact, conclusion of law, and recommendations of the PPAC to approve the application for certification for Clarence Horton III with all states and territories being so notified. Do I have a motion?
So moved.
That's President Narducci. Do I have a second?
Second.
Second.
I have Member Baker and even a third that we want to. Any conversation or discussion regarding this issue? Okay, then hearing none, I'll allow folks to unmute. And those in favor of supporting this motion, I would ask you to indicate by saying aye.
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 Any opposed by indicating nay? Okay, we have approval unanimously. Thank you. We will move on to 9D. This is the approval of the revocation of any and all educator certificates held by Leslie Bellin for breach of condition of prior settlement agreement. At this point, do I have a motion to enforce the terms of settlement agreement signed by Ms. Bellin and automatically revoke any and all certificates held by Ms. Bellin for a period of 5 years with all states and territories being so notified? I would also indicate that we have her counsel with us here if any board member would like to take advantage of that. But with that said, do I have a motion to the aforementioned motion?
So moved.
Member Baker, do I have a second?
Second.
Member Mack, thank you. Any discussion regarding this matter? Okay, hearing none, I'll allow folks to unmute, and once that is done, I would ask all those in favor of the motion to enforce the terms of the settlement and agreement signed by Ms. Bellin and automatically revoke any and all certificates held by Ms. Bellin for a period of 5 years with all states and territories being so notified to indicate by saying aye.
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 Any opposed indicate by saying nay. Okay, passes unanimously. We'll move on to 9E. This has to do with the presentation, discussion, and possible action on a request for rehearing. We'll go to E2. Director Williams?
Yes. Dr. Kaur, members of the board, in cases of rehearing, and Dr. Kaur will explain the process in a moment, the respondent's counsel, in this case Mr. Frazier, is allowed to provide information to the board on why he believes his client should have a rehearing. We did hear a lot of information in his public comment for the reasons of rehearing. If Mr. Frazier has additional information he wishes to share with the board, he is welcome to do that at this time. And then Dr. Kaur, following Mr. Frazier's comments, then we would have our legal, which is Kathleen Harrington, who is on the phone, provide information to the board from the state side.
Thank you.
So do you have any additional information to share with Mr.
No,
Frazier?
just with, we heard from you earlier during the call to the public, but if there's additional information or a couple of key points you'd like to reiterate, we'd love to have you take that opportunity.
I would just add one thing I didn't bring up the first time. I won't repeat the other stuff. I believe those email notes are presently with the Santa Cruz County Attorney. That's who a subpoena would have to go to now. But of course, once the hearing was over, I didn't have subpoena authority anymore. So I think there was a comment, well, we haven't produced the notes. Well, we couldn't get them after that hearing was over. So, and there are probably other things, if questions are asked, I'll stand right here.
Anything else you'd like to add?
I would just incorporate everything I said before.
Okay, yeah, no, that's fair enough, and I do appreciate that. I just, again, just want to make sure you have ample opportunity before we hear from what would be the state, I guess.
And we did also request that the penalty be reduced, partly because of all of the things that I'm suggesting be reheard.
Right.
But also in general because this was heavily disputed, the facts.
All right. Thank you. Okay. Thank you. Director Williams, and a word or two from the state, if you will.
Yes. Kathleen Harrington, are you on the line, and do you wish to provide the state's perspective?
I am, and I can. I'm not sure there's much that I would add in addition to my papers, other than to note that this was a unanimous decision by the 6-member PPAC committee who heard all of the evidence, made specific notations on the record that they did not find Mr. Jimenez credible to certain points. And, the questions of the counselor's statements, I represented on the record that I did not know about those until the day before. While those were a point of the PPAC's deliberations, I don't believe that was necessarily the linchpin. There was, the subpoena, the text messages, those were referred to in the police report. So I don't, again, think that made a difference to not have them there. Would it have been better? Maybe, but I think in many cases we go forward with a police report and not the specific, text messages or specific interviews. So if you have questions, I'd be happy to respond to those.
And Dr. Cord, now since both sides have presented their perspectives, if the board members have any questions of Mr. Jimenez's counsel or the state, this would be the appropriate time.
Thank you, Director Williams. Do any members of the board have any questions for either members of council? Okay, thank you. And with that, then I would ask, do I have a motion to deny Mr. Jimenez's request for a rehearing under AAC R7-2-709 and determine that there is no basis in law or fact for rehearing in this contested case?
This is Member Broussard, so moved.
Thank you, Member Broussard. Do I have a second?
Second.
Second, this is Luke.
I think it was Member Baker who beat you in by a hair, Luke. Member Baker with the second. Any discussion or conversation? Okay, then you can go ahead and unmute, and I would ask for all those in favor of the motion to deny Mr. Jimenez's request for a rehearing to indicate by saying aye. Aye.
Aye.
Aye.
Any opposed, please indicate by saying nay. Okay, I believe that is unanimous approval of that item, and we'll move on to number 3, the case for Tasha Smith. So once again, we will invite counsel to come to the stand to reiterate some points or make some new points, and then we will hear from the state.
And thank you for the opportunity, but I will rely on the arguments I made earlier. I would, if the board will acknowledge my client's presence and allow her the opportunity to make some brief comments, I'll give her my time, if that's okay with you.
Certainly. Yes, please. Ms. Smith.
Thank you.
Yes, of course.
Thank you, President and board members, for allowing me to speak. I just would like to acknowledge that I take full ownership in the DUI incident. The case with the disorderly conduct.
Could you
am
slow
I not?
down just a
Okay,
little bit?
sorry.
And I know this makes it tough, but it makes it tough for, I want to
Okay.
hear what you have to say.
Okay. Well, I was owning full ownership of the DUI. I take full responsibility. There is no excuse. I own that 1,000%. The case with the disorderly conduct. I was actually planning on fighting that case. I appeared with a witness and an attorney. The prosecution did not show up with any witnesses. The district I was working for at the time gave me 3 months to pay 3 months to settle the situation. They knew my character. They were supportive. And the trial got extended to a time past my due date at work. I got panicked and went ahead and pleaded to the disorderly conduct. I was assured by my attorney at the time that that should not impact my teaching certificate. If I had known, I would have went ahead and fought the case fully. So I just want to state that I take ownership in the DUI, but the disorderly conduct, it was a case I was planning on fighting. And if I had known it would have impacted my teaching certificate, I would have. So I just want to state that. Thank you. Thank you.
Thank you, Ms. Smith. Some words from the state. Director Williams?
Dr. Core, members of the board, this is also Kathleen Harrington's case, and so if she wishes to address the board at this time, Kathleen, you may do so.
Thank you, Vice President Core, members of the committee. I again laid out the state's position in the papers. And I appreciate what Ms. Smith is saying now before you, that she would have liked to have contested the disorderly conduct both in court. And I will also point out that in the PPAC hearing, she also elected not to testify. So she did not provide any context or explanation about that disorderly conduct plea that she made. So we have an 18-month suspension. Frankly, I think given that disorderly conduct was much akin to a DUI because it was alcohol-fueled, we would likely have been looking at a 2 to 3 year suspension given the Dui Matrix. But the PPAC decided 18 months, and I don't see any reason to reduce that, as counsel suggests, to 12 months. I'd be happy to answer any questions.
Thank you. Do any board members have any questions for either side in this matter? Okay, thank you. Then hearing no questions, I'll entertain a motion, and we can certainly have conversation after a motion in a second. But at this point, do I have a motion to deny Ms. Smith's request for rehearing under AAC R7-2-709 and determined that there is no basis in law or fact for rehearing this contested case. Do I have such a motion?
So moved.
President Narducci, do I have a second?
So moved. Wellborn?
Thank you, Member Wellborn. Any discussion regarding this matter? I thought I heard someone trying to speak. Now, any discussion regarding this matter? Okay, then I'll allow folks to unmute and I'll call a vote. All those in favor of denying Ms. Smith's request for a rehearing, please indicate by saying aye. Aye.
Aye.
Aye.
Aye.
Any opposed, please indicate by saying nay. I believe we have unanimous approval of that item. Thank you. So we'll move on to the final agenda item of the day, and that is a summary of current events, future meeting dates, and items for future agenda items. Director Williams, do you have anything to add at this point?
I do, Dr. Kaur, because I want to keep you all along a little bit longer. As stated in my executive director update, the board can be noticed that they will receive an update on the exit survey for the school closures at the August meeting. In addition, I just wanted to give a status update. As you are aware, the board changed some procedures and policies around AOI applications. AOI stands for Arizona Online Instruction. Staff pulled some numbers on Thursday at 3 o'clock. We have 17 total applications thus far from district schools. 9 are brand new AOIs. The remaining 8 are what we call expansions. So they may already be approved for 712, but they're looking to expand down. So I think we were interested to see how many people would apply to go through the AOI process. And as of Thursday, we have 17. That window does not close until July 1st. So there could be more districts applying for that. And I feel pretty good that we will have money in this year's budget to pay for some of those reviews, and we will not have to ask districts to do that.
Great. Member Baker.
So the board has to approve those applications, correct, after review?
So based upon last month's procedures, if they receive an application and they pass the paper application, then what will happen is I will probably send them a letter with my signature on it saying you're preliminarily approved for a year, but you still have to go through the demonstration portion, which the demonstration portion will more than likely occur early fall, mid-fall, at which point the whole application would come to the board for approval, for full approval of the AOI program.
Vice President Narducci, just to clarify, if a district has submitted an application and you review it and it looks good and you send them the letter, they can move forward for 1 year.
Correct, for 1 year.
Right.
And the reviewer, just to clarify, I'm not reviewing them. Our
Right,
reviewers are.
But you are, yeah.
Yes.
Okay, I
yes.
get it, yes.
And we're trying to do that as quickly as possible, knowing that some school districts are starting mid-July. So that's why the July 1st deadline, and we can get those letters out. We've been sending in the applications as they come in, so they're being reviewed as they come in.
Okay.
Excellent. Anything else, Director Williams?
I'm sorry, that concludes my
Okay,
update.
very good. Anyone else have any closing comments?
This is Member Wellborn. I have a question.
Continue. Yeah.
Executive Director Williams. In our packet, we had a copy of a letter that came from the county supervisors going to the governor, and I realize it's only been a week. Is there any information with regard to actions or discussions that are occurring because of that letter?
board members of the board, the letter you're referencing was not in the state board packet. It was a letter that had been sent by staff to you guys as mail. As you know, we regularly receive State Board of Education member mail to our offices, so that was us forwarding that mail on to you all. As far as what was in the letter and movement forward, we believe there will be movement this week at some point through the governor's office. At this point, I don't have any additional specific information to share with the board on that.
All right. My apologies. I confused on how it came to us. I apologize.
Not a problem.
Any other questions or comments by any members of the board? Well, I want to express my appreciation for everyone sticking with us through a pretty complex and nuanced agenda. But at this point, I will adjourn this meeting at 12:17 and wish you all a wonderful summer, healthy and happy, and look forward to seeing you soon.
Thank you.
Thank you.
Thank you.
Thank you.